friends, let us understand what Section 10A of the Companies Act 2013 lays down, and what is the importance of the company which has been registered on or after 2nd of October 2018. The Companies Amendment Act 2019 that inserted a section that is known as a Section 10A under the Companies Act. So Section 10A means it's a commencement of business, means any company which has been registered on or after 2nd of October 2018, then that company has to file the INC 20A, that's a commencement of business form, within a period of 180 days from the date of registration of the company. So it is a mandatory compliance. And this amendment of Section 10A that definitely reclassified certain offences as a civil default and also replaced the fine with the word fine with the penalty. So Section 10A, that's a amendment section that has been done in 2019 as under the Companies Amendment Act 2019, and that as an insertion of Section 10A under the Companies Act 2013. What will happen if it is non-compliance? It means company do not comply with these compliance formalities, and if it is a non-compliance, then what will be the consequence of that? Section 10A of subsection 2 of the Companies Act 2013 clearly lays down of non-compliance consequences. A company shall be fined of an amount of 50,000 rupees, and every officer who is in default will have to pay the penalty of 1,000 rupees per day to the maximum of 1 lakh rupees per officer. So for example, there are 3 directors and in any company, then if it is a company is in default of compliance of Section 10A, then under that condition the total penalty can be 50,000 for the companies, and for 3 directors for 1 lakh, 1 lakh, 1 lakh. It means 3 lakh plus 50,000. So total penalty may be imposed up to 3 lakh 50,000 if in a company that have 3 directors. So nowadays Ministry of Corporate Affairs have also imposed non-compliance as a penalty on the several companies who has not done the compliance. So where non-compliance have attracted the penalties, so MCA is not hesitating to impose the penalty on many companies. So for 1 year or 2 years or 3 years, there have been several companies on which the penalty has been imposed just because the companies do not have the compliance of this particular section. So companies, each and every section and provisions which is applicable on the particular company, that need to have the compliance and up to date the compliance, that is a mandatory, and the action taken by the Ministry of Corporate Affairs as a regulatory body, the company must be a vigilant and must be have all the compliances part which as per the company law of the different section and the provisions have to comply and fulfill as per the up to date. So if company there is an order of the adjudicating authority, and if the person is not agreed with the decisions, and if they find it is the impugned order, then under that conditions a person can file the appeal to the regional director within a period of 60 days from the date when the order is communicated to the persons. So if a person decide that they need to file the appeal, the period that is 60 days. So within 60 days need to file the appeal against the impugned order passed by the adjudicating authority to the regional director. To get more information related to the company's law and the corporate laws, please subscribe our channel. Thank you so much.